Welcome to Case by Case. This is a podcast series brought to you by Calum and Luke Zadkovich of Xyloploid Zadkovich. How are you doing today, Calum?
I'm doing very well, thank you, Luke. How are you?
Good. Did you manage to catch any of the Eternal Bliss live from the Court of Appeal today?
I tuned in briefly. I was interested to see who counsel was going to be on the case, or at least I saw that it wasn't that Alex Wright and Tom Bird weren't leading as they were in the High Court, and I was interested to see who was on at QC level. But unfortunately, too much work to be able to enjoy the full thing. I saw a few summaries.
Yeah. Look, I think it's going to be an interesting one for those demurrage aficionados out there. It's definitely one to follow. I know we've got a few cases where this has kind of come up, or issues around this type of issues. So I also noticed that there was some reporting being done on it outside of maritime. So I think there is interest in the wider LD, liquidated damages type point.
Yeah, I mean, this is a case that will be coming to a case by case near you very soon, I'm sure.
Exactly. But today, we're not here to talk about the Eternal Bliss. We've got a London Arbitration to talk you through. And I dare say this might be one of our shorter episodes. Let's see.
Yeah, you never know where these things go. When I read it, I thought it was going to be a shorter one. Then I found it a bit of an interesting kind of aside. So we'll see how tangential we go.
We have definitely said that before and ended up talking for half an hour. So let's see how we get on, Calum. So this is London Arbitration 20/21, not the year 2021, but 20/21. And we're talking about nominations of discharge ports. And it's not an uncommon situation where a charter party may provide for, in this instance, let's just say the discharging ports, to have a range of options where the destination may be, and then at some point there's an obligation on the charterers to nominate what the discharge port is going to be. And there can be sometimes, price differentials depending on what port is nominated. And often you'll find that nomination has to happen before a certain point in time, so that the shortest route to the nominated discharging port can be calculated. So that's the type of case we're talking about today. In usual fashion, Calum, would you like to give a more detailed summary of the facts?
Yeah, let's go through the relevant facts for this one. So we have a charter party, which was for the carriage of 60,000 metric tons of soybean in bulk with a charterer's more or less option. It was from Brazil to 1 to 2 safe ports in China, and on the terms of the charter party, it was a voyage charter party, and on the terms of the charter party there was an uplift if the nominated port in China was Taichung. There was also a requirement under the charter party that the declaration of the discharge port was given as soon as it was known, and on top of that there was also a requirement that the declaration was given when passing Singapore. And then the final point, which I think was critical in the way the arbitrators found this case, was that the charter party provided that freight was going to be deemed earned on shipment discountless. The exact wording was that it was discountless and non-returnable, vessel and or cargo lost or not lost. So there was an obligation on the charterer to pay freight irrespective of whether the voyage was completed. The cargo was loaded on the 6th of June, and on the 20th of June, there was a nomination of Zhoushan and Taichung. I think it was for lightering at Zhoushan before discharging the balance cargo at Taichung. But either way, that nomination or that discharge port would trigger the uplift in the freight rate that was included in the charter party because they'd nominated Tai Ching. And as I mentioned, there was a provision in the charter party that said that there was little uplift for a discharge port nomination of Tai Ching. The charters then changed their mind about 2 weeks later, on the 3rd of July, and they said, actually, no, we want to go to Tianjin. And there was then an invoice presented from the owners to the charterers, including the uplift that would have applied for a discharge at Taiching. That precipitated a dispute about whether that invoice was payable in full, leading to the invoice being paid into an escrow account before the vessel ultimately discharged at Tianjin. And the dispute was around whether or not that increased freight was payable for a discharge at Taiching, notwithstanding the fact that there was never a discharge at Taiching. There was only ever a discharge at Tianjin, which was the, I guess, quote-unquote, revised nomination, to the extent that one can revise a nomination under a voyage charter party.
Yeah, thank you. It's a good summary. It's one of these cases where what happens when a nomination is made when you have an option in a contract like this. And so we're dealing with a charterer's option to declare nominate by a certain point in time where the discharging ports are going to be. And then once they do that, what is the effect of that? And as we know, and reading through this when we got into it, I was expecting the ultimate decision actually that went the way that it did, and that is once a nomination is made on the basis of the 1992 case, the Jasmine B. For those who'd like a citation, that's 1 Lloyd's Report 39 of 1992. Once the nomination is given, it's effectively written into the charter as though the charter was always to the nominated discharging ports. It's almost like it's now a fixed contract, and you look at whatever happens after that point in time as though the contract was always for the nominated discharging port.
I think that's exactly the way to think about it, was that when you give this nomination, at least in accordance with that case, it's as though you just rewrite the charter party. So it's not a charter party to 1/2 safe ports China. It becomes a voyage charter party to, in this case, Zhoushan and Taiching. That's the effect of this written in case law in the Jasmine B. Yeah, exactly.
And therefore, you then look at it through the lens of, well, we have a charter party to definite places. There's then subsequent to that, a decision by the charterers to take the vessel elsewhere. What would then happen? What would happen in the usual course? Well, there'd be a right to charge for additional freight if the owners were going to contemplate that, because the charterers no longer have that right. The contract is fixed to go to certain places. So the charterers would effectively be seeking the owner's indulgence to do something outside of what is contractually agreed.
Exactly that. And there were a number of arguments raised in response to that by charterers, including, this is a total failure of consideration. You can't charge us freight for Taiching when we never went near Taiching. And there were also a number of arguments raised in the kind of waiver, estoppel, and unjust enrichment triumvirate. And those, I think, had a pretty limited shelf life, because from the moment that the invoice was presented for the freight, including Taiching, notwithstanding that discharge was going to be at Tianjin, it was always sailing under protest. It was expressed in the escrow account into which the freight was paid that this was without prejudice to this dispute and everything else. So I think that the arguments on grounds of estoppel or waiver, having the waiver arguments essentially being, well, you completed the voyage to Tianjin, so you can't now claim freight to Taiching. I think they were always doomed from an early stage.
Yeah, I think that's right. And we see this regularly. I know we probably see it on our own cases as well. But in reading these judgments, I know I often find that there tends to be this inclination to throw all types of arguments into the mix. And we've had this discussion before, I know, but a number of these arguments just seemed, out there. I couldn't quite see how waiver or estoppel or unjust enrichment was really going to get off the ground in circumstances where there had been a clear reservation and they were, proceeding on the basis of setting up an escrow account. Surely they're going to do all that under reservation and make sure that they're preserving the contractual position and those arguments. And it seems like the arbitrator gave that quite short shrift. Yeah,
exactly. But I think I guess their more interesting argument was this total failure of consideration point. Looking at Section 54 of the Sale of Goods Act, kind of by analogy, that a failure of consideration which justifies repayment is a failure of the contract performance. It ultimately didn't go very far, and I think in part that was due to the wording in the charge party that I referred to when I was going through the facts, which said that the freight was payable whether or not the cargo ultimately made it. Even if the cargo was lost, the freight was payable. If the vessel was lost, the freight was payable. So it was difficult for them to say that there was this complete failure of consideration when freight was deemed earned so early in the process.
Yeah, exactly. And I think it's a case that's a useful reminder of what happens when there are options. And what has happened here is not always the outcome when you're dealing with options. In a contract where you have to make a nomination by a certain period of time, then you've got the Jasmine B, and once the nomination is made, it's then written into the contract, as happened here, as we see in many situations. But it is possible, if the contract provides for it, for an option to be changed. It requires express wording for that, and it also interplays with the concept of an election. Where when in contracts, the one party gets given rights of election, or certain rights accrue, and they have to make an election within a certain period of time, even if that's not provided for expressly in the contract. Then that's another concept to be thinking about in other cases where options are involved. But look, that's kind of a bit of a by the by in this type of situation where which we see in shipping regularly, where there's a nomination to be made, whether it's as to the vessel that's going to be nominated early on, or a loading port or a discharging port, or other types of nominations. Generally speaking, those are going to be written into the contract as though they were made at the outset, once made.
Yeah, exactly. The tangent that I was thinking of was actually different to the option side. But rounding that one out, that was mentioned in the Jasmine B case, where the judge in that case, although finding that typically where there's one of these nomination provisions, typically what you're doing in making the nomination is scoring out the 1/2 safe berths and writing in the name of the nominated berth. He did say expressly that this wouldn't be the case if there was special wording in the charter party to the contrary, or there was some sort of special wording that allowed the charterer to make multiple nominations or to change his mind. So I think it's another one where the close attention to the phrasing used for the option or the nomination is always going to be critical. But I think it's clear that the sort of fallback position will be the Jasmine B position, where you're writing in the nominated port.
Yeah, and the other point on that is when you have a contract where at least you think, or there's the ability to make multiple nominations, that you're very careful about the wording used in the nomination itself. And that there are ways of, I wouldn't say giving dummy nominations, but there are ways of giving without prejudice nominations. that might not bind you to the contract. That gets complicated, but it's just a thought that I had, that often what happens is these things are done without consideration of what the contractual position is, or whether you are making a nomination or taking an election, and actually there are ways of perhaps serving a commercial purpose or serving a dialogue purpose with the other side, but through the language that you use in your nomination or correspondence, you don't actually formally commit yourself contractually to that.
I think that's right, and I think so. There are two. There's another point here on that. If the charterers, so the charters were required by the charter party here to give a declaration 10 days prior vessel passing Singapore, and also charterers agreed to declare discharge port ASAP once they know. I wonder what the situation would have been if the charterers simply did not comply with those provisions, and then ultimately waited until it was too late for them to comply with that obligation, but then nominated Tianjin directly as their first nomination. My instinct is that would be a breach of the charter party, but it wouldn't have the effect of writing anything into the nomination provision. So the effect of that breach would be limited to the losses actually suffered by the head owners. They wouldn't have a contractual claim for the uplifted freight. They would simply have a claim in damages for any additional losses suffered by the late nomination.
That's my instinct on that as well, that they'd need to establish the loss. What is the loss that flows from that breach? The breach in missing the timing. And so then that's when you can start to get into, well, if the vessel was able to continue on its merry way towards China, and the ultimate nomination was given late, but at a point when it wasn't adding additional steaming time to the trip, then query what the losses are.
Exactly, and that moves me more helpfully towards the segue that this made me think of this case, which is subtle, which is it just made me think of a redelivery notice in a time charter party, which is treated differently. And then I went down the rabbit hole of reading into how redelivery notices in time charge parties are treated, and it's actually a very interesting area of law. There's one case on it that made it to the High Court called the Zenobia. Again, for our citation fans, that's 2009 to Lloyd's Rep 139, and the time charter, the authors of time charters suggest that this is a point that merits further consideration by the Court of Appeal. But essentially, the decision in the Zenobia is that if you have you're required to give redelivery notices of 30, 15, 10, 5, 4, 3, 2, 1 days, then the giving of those notices simply means that you're not in breach of the charter party. You're not in breach of your requirement to give notices for redelivery. You're still able to redeliver the vessel within the redelivery window, having not given those notices. There's no way that a redelivery notice of 10 days binds you to redeliver on the date 10 days after your redelivery notice. You're just giving those notices so you're not in breach of the obligation. And obviously, if there's any loss occasioned by your failure to give a notice, then that's claimable. But there's an interesting distinction there between the voyage charter party situation, where things are quite clearly written in, and the time charter party situation, where you do this to avoid being in breach.
Yeah, I remember the Zenobia because I had a case that turned on it. And the Zenobia, correct me if I'm wrong, but isn't that the one where the arbitrators made a factual finding that WP, when given, along with all the other types of reservations, AGW, all going well, WOG, guarantee, and UCE, and others from memory, but maybe that was it. But they made the factual finding that WP meant without prejudice rather than weather permitting.
Correct. It was exactly that.
That's right. And then did it go to the court, or was it in a subsequent decision? I think it went to it was appealed, wasn't it? It went to the High Court, and I think the High Court said that they queried that factual finding, but found themselves bound by it. And once that finding was made, then the notice was without prejudice, approximate redelivery notice.
Exactly. That's exactly what that case meant, or that's kind of one of the features of that case. That's a very good memory. Well done.
I remember it because I studied it for a case and went over it, and we actually, without getting into any specifics, but we did go through submissions on that, and each party, I think, ultimately resolved, but each party were kind of liking the decision, but also not sure it was going to hold if really tested. It's one of those decisions where it's a neat answer depending on which side you're on it, but at the same time, you wouldn't really want your own case to be decided on it.
Yeah. I think when you have something like a book that's as respected in the world of shipping as time charters, saying that it merits consideration by the Court of Appeal, that probably speaks volume. But I think one of the interesting points there is whether the giving of the authors of time charters suggest that giving a redelivery notice means that thereafter you're giving some sort of undertaking that you will not give contrary in voyage instructions to owners. And the question is then, what's the effect of that undertaking? Whether there's some kind of estoppel preventing you from giving any other voyage instructions, or whether we're into a breach situation. I think it's an interesting point, and maybe it's one that we'll see, not too far down the line.
Yeah, there was also, it's coming back to me now, there's also something about whether you took an objection on whether the approximate redelivery notice was actually contractual, because and this kind of goes to the point I was making before in the nomination. If you gave an approximate redelivery notice and included WP, meaning without prejudice, query whether you are actually giving a contractual notice or not, because you're not really giving it on an open basis. Are you really giving an approximate redelivery notice in that situation? I'm not sure you are, and the point certainly wasn't taken up in the Zenobia, but the issue there is, if you receive a notice that contains without prejudice, you've got to really think, is this actually doing what it's supposed to do under the contract when the other side is reserving their position so significantly? And similarly, if you're on the issuing side, whether you can get away with, so to speak, issuing a without prejudice type nomination, which you could imagine a party kind of doing that in the situation of the arbitration case we're talking about, Calum, and saying, look, saying without prejudice, we're saying go to Zhujian and Jiaxing, and that kind of slides through. It meets the 20-day requirement, and then a further point down the track, you actually issue an open one to go to Tianjin. And then I think you're in that scenario of probably having breached the original obligation, not locked in discharging port, not have it written into the contract, and then yes, be in breach. But what loss flows from that?
Well, exactly, and if you, in a way, it's quite a neat way to protect your position if you're a charterer, because you're not really giving a notice under the charter party, but provided that ultimately will be the discharge port you want to go to, it's hard to see how owners could suffer substantial loss by following that WP nomination. The difficulty, if you're an owner's side, then you want to turn around to charterers and say, no, it's not possible for you to give a without prejudice nomination of a discharge port under a voyage charter party, because following the Jasmine B, a nomination of a discharge port is with prejudice, very clearly with prejudice. There's good authority saying that you are in fact prejudicing your ability to go to nominate any other discharge port once you make your first nomination. So I think you're right.
Exactly.
It's not a conforming notice.
Exactly. And I know from having dealt with the Zenobia, which what year was that? Have you pulled it up?
It was 2009.
Wow, another one where can't believe so long has gone since that case. And what was my point going to be? That's right. So after that decision came out, I can remember on a number of occasions going to clients and saying, look, I think we should have a look at what wording you're using on your approximate redelivery notices, and make sure they're in line with the case and they give you the flexibility that you're looking for. So anyway, interesting. I like your segue. Thanks for taking us there, Calum. And how long have we been going for? We're
probably pushing 25, 30 minutes now. So
yeah, there you go. We always do it, don't we?
Exactly. There's a lot to think about in these cases. There always is more than when you scratch the surface and you start getting into it. It's part of the joy of the job, and part of the joy of doing this podcast is that there's always more to think about.
Yeah, absolutely. On that note, we'll let our listeners go. But thank you very much for getting to the end of this episode. We hope you've enjoyed it. It's been a bit of a trip down memory lane for me. Thanks for your time, Calum. Always good to chat with you.
Cheers, Luke. Thanks again to all our listeners. And as I always say, if you do enjoy this podcast, then please do hit subscribe or follow or whatever the right button is according to the platform that you're listening in on.
Until next time, take care.